So contracts is there almost every time. And we have three basic patterns: formation, conditions, and breach and remedies. And to answer these questions, you have to know the basic core.
Well, when formation is the main issue, they give you a lot of facts that go to offer and acceptance. And you have to analyze every communication in the hypothetical and decide whether this is a valid offer. If there's been a valid offer, is the next communication an acceptance? With every communication, analyze that. If the hypothetical doesn't allow you to form a contract, if there hasn't been a valid offer or a valid acceptance, then you have to know the alternative theories. And a lot of the time, even if you think there has been a valid offer or a valid acceptance, you should raise an alternative theory in case. Unjust enrichment, detrimental reliance, accord and satisfaction.
Yeah, and we're not going to be reteaching these. If you need to learn about these subjects or refresh your memory, you can see it in our lecture in Power Law.
The only comment I was going to point out is if the fact pattern tells you you have a valid contract, or that there's a signed written valid contract, you're looking at the facts and figuring out who was the offeror, who was the offeree, and you can't determine that, formation is not the issue. There basically means they're already telling you that you have a properly formed contract, and it's going to be one of these other basic fact patterns or hypos that we're going to talk about in just a second.
So if you get a fact pattern like that, and you form the contract in about a half a paragraph or so very quickly, you'll do fine. If you spend 2 pages on formation, you'll fail that essay. So you have to be really careful.
Second kind of hypothetical is one that really focuses on conditions and modifications.
Okay. So basically, when does a date become a condition, a mere date in the contract? Suppose they say must be done by September 1, and it's not done by September 1, it's done by September 5. How does that work? How does that date work?
I was just going to say it depends on if we're dealing with a common law contract or UCC, because if it's UCC because of perfect tender, that date is definitely a condition. If it's common law, then the answer is it actually depends again. Do we have time is of the essence language? We have to look a little further because it could just be a mere promise without anything more.
So the big thing that happens is somebody attempts to modify the contract after contract formation. And what you need to know is a modification in the common law is not valid unless there's new or additional consideration. And that is a key hypo. It's tested again and again. And again, a date all by itself in the contract, in a common law contract, is only a promise. It is not a condition.
So now you see why they test those two topics so often, because it's a way to get at whether you know the difference between UCC and common law.
And if they ask you for remedies, you really have to do the gamut. So here we're just giving you the basics. If they say contract, if it's a contract, and they say what remedies would be available, you've got the word remedies in the call of the question, then you've got to go down and begin with expectation, which is the benefit of the bargain, consequentials, liquidated, punitive, reliance, and restitution. And you have to checklist through, and generally you have to address all of these if it's a remedies question in contracts. So you really have to know those subjects.
And then the next remedy is the big one that has so many elements, specific performance.
They're looking for you to put those elements and as a head note, each one of them, right?
Right. Subhead note each one and talk a little bit about what it means. So basically you want to head note the issue and then give the standard or present some law. So legal remedy inadequate. Can anybody elaborate on that? If it's speculative, how does that work?
The main thing I think of, and we have it there, is unique goods. So if they tell you, there's a special car, or there's a coin, a rare coin, only one of a kind, there's only two like it in the world, you see facts like that. Well, basically money is not going to cut it because it's such a special thing. And so that's where specific performance may be a good remedy.
You can work your way down the rest of those. And again, we have quite a bit more detail in power law or in proponics.
Yeah, so basically that's one you've got to know. Replevin, got to know it. So basically, if you have goods identified to the contract, in other words, a contract for the sale of a car, and there's a breach and cover is fruitless, then you can, in that particular circumstance, ask for the goods back right away. So this is a quick way to get goods back. Otherwise, if you have to wait for specific performance, you'll never get it.
And recently, fairly often, rescission has been an issue.
Yeah.
Right. And you've got to memorize the grounds, mistake, fraud, and so on. Reformation is barely tested. It's a little issue, just that you need to rewrite the contract. There was an error in the writing. That happens sometimes too. This is a summary of the issues you must know.
Notice what we've highlighted here, areas where the common law differs from the UCC. I already said it, but hypothetical writers like to test these issues because it pulls for your detailed understanding of the difference. So in acceptance, the common law versus the UCC. Common law has the mirror image rule. UCC has 2-207. In modification, common law requires consideration. UCC modification is fine as long as it's in good faith. The effect of a date, Dr. Sakuzo already covered that. Misrepresentation versus fraud versus non-disclosure is reasonably often tested. Less often, mutual mistake versus unilateral mistake. And I know law schools generally go crazy over parole evidence rule. We rarely see that in a contract hypothetical. Modification, right, we see often.
Exactly.
Condition versus promise, again, we already discussed that basically. Waiver is very, very often in a contract's hypothetical, as is anticipatory repudiation or wrongful prevention, which is by conduct. And then often, recently, the bar will test request for adequate assurances. It's a UCC requirement. So there's the rule for adequate assurances. If you're dealing with a UCC hypothetical, a sale of goods hypothetical, something in the hypothetical raises a fact that makes one of the parties think that this contract is about to be breached. If there are reasonable grounds for insecurity, then the party may submit in writing a demand for adequate assurances and suspend his own performance. If those assurances are not provided within a reasonable time, not to exceed 30 days, then that's a repudiation.
You've got to know that law because they've tested it a couple times in recent bars.